For the past few weeks, several countries of the world have been on partial or total lockdown as a result of the current global pandemic, Covid-19. As a result, courts have been unable to sit and conduct hearings in their usual manner. In order to dispense their duties, judiciaries all over the world are devising innovative techniques to keep the court system running. The new approach being adopted by the courts is the subject of today's episode. I am Abolade Akikumi. Welcome to Insight Legal. For the purpose of containing the virus, several countries of the world have policies prohibiting gathering of people. In Nigeria, different states have different policies in this regard, depending on the circumstances. On the 29th of March, President Muhammadu Buhari, in an address to the nation, ordered that there should be no movement in Lagos, Ogun, and Abuja. As a result, courts have been unable to sit. Automatically, all cases in states that are affected are adjourned, even without a circular in that regard. Now, let's go international. As opposed to the situation in Nigeria, safety measures against coronavirus have not prevented the courts from dispensing their judicial functions. In China, where the virus first broke out, 59.3% of all cases in the country are now being done online through video conferencing. As published on the website of the Supreme People's Court of the People's Republic of China, nearly 550,000 cases have been filed, 440,000 payments done, and over 100,000 cases heard, all done online since the 3rd of February. In the United Kingdom Supreme Court, also called the Supreme Court of England, no longer sits and conducts hearings in the Supreme Court building, but now does almost everything online. In order to keep the wheel of justice running, justices of the Supreme Court now deliver judgments remotely from places such as homes, offices, and so on.
I'm about to summarize the judgments of the Supreme Court in an appeal by Mrs. El Ghazouli against a decision of the Court of Appeal. But before saying anything about the appeal itself, I must mention the obvious fact that the judgment is being delivered remotely. Indeed, this is the first judgment of the court to be delivered in this way. And of course, as everyone will realize, the reason that it is taking place like this is because of the COVID-19 pandemic. Obviously, it would be preferable that the judgment be delivered in open court, but in the present circumstances, that is simply not feasible. The working practices of the court have had to be adjusted so that we comply with public health guidance and to minimize the risk of COVID-19 to court staff and users. It is a fortunate circumstance that in this day and age, it is possible to function effectively as a court by means of technology. And the court is determined that with the enormous help and dedication of our IT staff, we will continue to discharge our duty in the administration of justice.
The court hands down judgment today in the case of Barclays Bank plc and various claimants.
This is the judgment in the appeal between ZipFit and Her Majesty's Commissioners of Revenue and Customs. I'm delivering this judgment on behalf of Lord Sales.
Before now, the validity of a judgment delivered outside the courtroom could have been a very contentious question of law. However, COVID-19 is shaping our lives differently, including judicial systems. In Australia, the High Court of Australia, which is the highest court in the country, conducts hearings and delivers judgments only on urgent matters. The same applies to the United States and Canada and several other advanced countries of the world, with electronic filing in place. Thank you so much for watching today's episode. Please make your comments below on what improvements can be done, and please subscribe to this channel to get updates on subsequent videos.